Dear learners, today in my lecture, I propose to discuss legal incidents of a valid waqf. Already I have discussed historical background of the waqf, importance of the institution of the waqf, meaning and definition of the waqf, as well as ingredients or basic characters or salient features of a valid waqf. Today, in my lecture, I want to explain legal incidents of a valid waqf. Legal incidents here simply means what will be the implications of a valid waqf according to the Muslim law. So, the legal incidents of waqf are as follows. There are three legal incidents of a valid waqf, and they are: number one, irrevocability, perpetuality, and inalienability. Meaning thereby, first of all, I would like to clarify what is meant by irrevocability in context of waqf. In simple words, irrevocability refers basically to the power of the waqif. It means that as soon as, in compliance of the necessary formalities, someone dedicates his or her property as waqf. On the declaration of the property as waqf, a waqf comes into existence. As soon as a waqf has come into existence or has been constituted in compliance of the necessary formalities prescribed by law, that is Muslim law, this charity comes into existence, that is waqf. Once it has come into existence, it becomes irrevocable, because in previous discussion, I have told that all the transactions involving the devolution of interest in a specific property up to certain stage is revocable, means it is within the power of the transferor to cancel or revoke the transaction, may gift or may will. In case of gift, donor is competent to revoke the gift before the actual or constructive delivery of the possession of the subject matter to the donee. And in case of the will or wasiyat, testator has got the power to revoke or cancel the bequest at any point of the time in his life, that is before the death. Bequest or wasiyat is revocable and can be revoked. But in case of the waqf, once a property is dedicated as a waqf and waqf has been constituted, in compliance of the necessary formalities thereafter, it becomes irrevocable, means it goes beyond the competence or beyond the power of the waqif or anybody else to revoke the waqf. A reason because in case of the gift, ownership is transferred by one human being to another human being or set of the human beings. So is the case in will. In wasiyat also, the ownership in a specific property is intended to be transferred by one person in favor of another human being, which is to take effect after the death of the transferor, that is the testator. Therefore, there is up to certain stage there is a possibility of revocation, because up to certain extent the ownership is not vested in the donee or legatee in case of the will and in case of the gift. But even in case of the gift, where property has been handed over by the donor to the donee, even it can be revoked uh, with the permission or by the order of the court. Similarly, in case of the will also, or even after the death of the testator, if it is not found valid, or it was made, or if the will was obtained by fraudulent means, it was liable to be cancelled. But in case of the waqf, as soon as it comes into existence, from that very moment, it becomes irrevocable. According to Abu Hanifa, a waqf is revocable and can be revoked by its founder unless the declaration has been confirmed by the court or by the decree. Means until the delivery of the subject matter of the waqf by the waqif to the mutaballi of the waqf, it is well within the competence or power of the waqif to revoke it. This is the stand or juristic opinion of Imam Abu Hanifa, the founder of the Hanafi school, relating to the waqf, that according to Imam Abu Hanifa, it is within the power of the waqif to revoke it if there is if the declaration to the effect of the waqf has not been endorsed by the qazi or by the order of the court. But his disciple Abu Yusuf, Imam Abu Yusuf, is of the different view on this point, and his view is contrary to the view held by his teacher as well as the founder of the Hanafi school, that is Imam Abu Hanifa. And according to Imam Abu Yusuf, once a waqf is made by dedication of the property for any religious, pious or charitable purpose, thereafter it cannot be the subject of further gift, further sale or subject matter of the inheritance on the death of its owner. And therefore, according to on the basis of this opinion of Imam Abu Yusuf, a waqf according to him is irrevocable once it has been validly constituted by the waqif by dedicating or devoting his any specific property for any definite purpose which is recognized under Muslim law as religious, pious or charitable. This is the view of Imam Abu Yusuf, which is the waqf is irrevocable, basically is rooted in the definition of the waqf as formulated by Imam Abu Yusuf. Therefore, on the basis of the definition of the waqf as given by Imam Abu Yusuf, a waqf is irrevocable once it has been constituted in compliance of the necessary formalities prescribed by the Muslim law. This is the opinion of Abu Yusuf. Imam Muhammad is also of the opinion that after the delivery of the possession of the subject matter of the waqf by the waqif to the mutawalli of the waqf, waqf become perpetual and will not be revocable and cannot be revoked by the waqif or anybody else. And in this way the theory has been propounded, a legal theory has been propounded by these two Imams, Imam Abu Yusuf and Imam Muhammad, the disciple of Imam Abu Hanifa, that waqf, once a waqf, always a waqf. And can, once if property has been dedicated as a waqf, it shall remain waqf until total extinction of the physical form of the property. Or even if the object for which the waqf has been created due to the attending facts and circumstances comes to end, even then the waqf will not be revocable or liable to be cancelled, because the object, if one object fails, then income from the property can be applied for some other similar object recognized under Muslim law as religious, pious and charitable. Ladies and gentlemen, the opinion of Imam Abu Yusuf on the point that waqf is irrevocable, this opinion of Abu Yusuf finds a resonance and reflection in section 3 subclass R of the Waqf Act 1995 as amended in 2013. That and section 3 subclass R runs like this: Waqf is permanent dedication of any property, movable or immovable, by any person. So it is a permanent dedication. And this expression permanent dedication basically is based on the opinion of Imam Abu Yusuf that once a property is dedicated as waqf, subsequently it cannot be subject matter of the sale, gift, even it will also not constitute a fresh stock of the descent in case of the demise of the waqif. A reason because Abu Yusuf assigned the reason to his opinion that since in case of the waqf, after the dedication of the property as a waqf, the ownership by fiction of law stands transfer from the waqif and waste in the Almighty Allah by fiction of law, and Almighty Allah becomes the real owner thereof. Only the physical only this mutawalli will have only the fiscal control over the property in order to manage the income and to apply it on the object for which a particular waqf was created by the waqf. Since the ownership is stand transferred in the name of Allah, Waqif is divested of his all rights of the ownership immediately. His right ceases to exist and continue in the property. Therefore, since by fiction of law, the rights of the ownership, proprietary rights of the ownership in the property dedicated as a waqf on the declaration by the waqif stand transferred or vested in the name of Allah. So thereafter, the thing which has come to the has gone into the ownership of Almighty Allah cannot be taken by any human being. And therefore, Imam Abu Yusuf says that waqf property will not be subject to revocation, or waqf will not be subject to the revocation by that donor, that is by the waqif. So, on the basis of the juristic opinion of Abu Yusuf, Section 3 has been framed, enacted, and opinion of Abu Yusuf has been given the legal status in the form of Section 3 subclause R, which runs like waqf means permanent dedication. So, permanency basically is the hallmark of the institution of the waqf, and therefore waqf is considered as irrevocable once it is constituted by the waqif in compliance of the necessary formalities prescribed by the Muslim. Dear learners, the next and important point or legal incident of the valid waqf is that it is not only permanent, but it is also perpetual. Waqf is perpetual dedication. If it is for a limited period or for a temporary purpose, it is wide. And perpetuity is basically ensured by fixing a perpetual object of the waqf. So, if the object of the waqf is perpetual, then waqf it automatically becomes perpetual by nature. According to Fatawa Alamgiri, perpetuity is also among the conditions of waqf according to all opinions, though according to Abu Yusuf, the mention of it is not condition, and this is correct. Thus, if a man says, I make this direct dedication on my children and adds things further, it is a valid waqf. Wherever the term waqf is used, permanence will be presumed as a matter of law. The rule against perpetuity does not apply over the waqf. So, the perpetuity of the waqf does not imply perpetuity of its object. Thus, if a waqf is created for the purposes which may fail or which are not perpetual, the view of Abu Yusuf is that the waqf is valid and that its benefit will accrue to the poor after the named object. About the implied permanency of a waqf, there were two schools of opinion. One school, that followers of the Abu Hanifa, maintain that in order to impart permanency, it must be expressly mentioned that ultimate benefit was reserved for the poor. Abu Yusuf, on the other hand, was of the view that permanence was implied in the use of the word waqf by the settler. His view was followed by Amir Ali and accepted by the Madras High Court in Sayyid Ahmad vs. Jalan Bibi. On the other hand, Bombay High Court preferred the Abu Hanifa's point of view. Now contemporary is controversy is uh, controversy settled in favor of the Abu Yusuf view that use of the expression implied reservedly the poor for the poor are not any other purpose recognized under Muslim law as religious, pious and charitable and permanent character in section 3 of the Musliman Waqf Bill 1913. So, the second and important legal incident or incident of a violate Waqf is that Waqf should be perpetual by its nature. The perpetuity of the Waqf does not imply perpetuity of its object. Thus, if a Waqf is created for the purpose which may fail or which are not perpetual, the view of Abu Yusuf is that the Waqf is valid and that its benefit will accrue to the poor after named object. About the implied permanency of a Waqf, there are two schools of opinion. One school says that followers of Abu Yusuf maintain that in order to impart the permanency, it must be expressly mentioned at the ultimate benefit of the reserved for the poor. On the other hand, Abu Yusuf, on the other hand, was of the view that permanency was implied in the use of the word waqf by user. His settler was followed, his view was followed by Amir Ali and accepted by Madras High Court in Sayyid Ahmad versus Julabai. On the other hand, Bombay High Court preferred Abu Hanifa's view of point, and now controversy is going on in favor of Abu Yusuf view with the use of expression expressly or impliedly reserved for the poor or any other person. Gentlemen, the third and important element of a legal incident is that every waqf after formation becomes inalienable by the waqif or mutawalli or any person having the interest in the waqf. Inalienability here means that once a property is dedicated as a waqf by its owner, the subject matter of the waqf becomes inalienable, means it cannot be disposed of by sale, but further cannot be disposed by sale, by gift or by even by any other legally recognized means. Therefore, every waqf after its constitution properly becomes inalienable. As the waqf property belongs to the God, no human being can alienate it for his own purpose. Consequently, waqf property cannot be subject of sale, mortgage, inheritance or inalienation whatsoever. This general rule has two exceptions. Waqf property may be exchanged for an unequivocal property subject to the compulsory retirement of the price and any other property. The power of exchange and sale is subject to the permission of the court. These exceptions to the rule that inability are therefore more apparent than real, since a new corpus is substituted for the old one and authorities and to the mutawalli, legally his position is that of a stranger and he is not an owner of the property, therefore he cannot alienate the property without express authorization by the either settler or the court. Try to understand here that inalienability is the hallmark of the waqf or property dedicated as a waqf. And therefore, under the modern law on the subject, a mutawalli is not allowed to sell, mortgage or alienate the waqf property without the consent of the Waqf board of the state concerned. Means once a property has been dedicated as a Waqf, thereafter that very property cannot further be sold for any purpose whatsoever may be. This is the inalienability or concept of uh, inalienability. And therefore, once a property is dedicated as a work, subsequently it cannot be subject of the sale. Waqif cannot sell the property to anyone for any consideration. He can also not mortgage the property after being dedicated as a work. Uh, Gift also is one of the mode of transfer of the property by the owner to the owner, but here it must be clear that where some property has been uh, gifted which was work by nature, such gift will be wide ab initio and will not create any right in the property of the work. As a general rule, there are two exceptions. Work property may be exchanged for an equivalent property or sold subject to the compulsory means in normal course of the circumstances, the work property cannot be sold. It will remain in the ownership of the and it will not be subject matter of the sale, mortgage, gift, or it will also not constitute a fresh stock of this descent. And therefore, if in any case mutawalli of the waqf wants to exchange the property uh, or he wants to sell the property, he cannot do so because this is beyond the power of the mutawalli. Thus, in Muhammad Yusuf versus Muhammad Sadiq year 1933, the Waqf deed directed the mutawalli to sell the Waqf property and construct a rest house at the Makkah from the sale of the proceeds. The court upheld this authorization. The court held this authorization uh, unlawful and held that court cannot grant him permission and with such prior sanction he can transfer the property by way of sale or by way of any alienation without prior sanction is void ab initio. Therefore, lease of the Waqf land for more than 3 years if agricultural land and for more than 1 year for other land also requires prior permission of the court for authorization by the settler. So, ladies and gentlemen, I recapitulate the points raised that the legal incident of a Waqf are that it is irrevocable by nature, it is uh, inalienable, it is perpetual. So, in irrevocability, perpetuity are the hallmarks of the Waqf so far as the Muslim law is concerned. And the hallmarks of the Waqf as pointed out under Muslim law, they have been duly given the place in the definition clause of the Waqf of 1995. So, inalienability here means that once a property is dedicated as a Waqf, it cannot be subject matter for the sale, gift, mortgage, or like purpose.